I'm Yvonne, mediator, life coach on divorce and custody cases, and I'm a principal at Kaffor Law Firm. We're located in Dallas, Texas. On this channel, I will educate and empower you to resolve your own legal issues. My goal is to save you time, money, and help you minimize conflict, stress, and anxiety while you're going through one of the most difficult times in your life. Now, this channel cannot and does not contain legal advice. The legal information is provided for general informational or educational purposes only. Before taking any advice based on such information, please consult with an attorney. We do not provide any legal advice, so reliance or the use of any information on this channel is solely at your own risk. I'm going to give you a tip. If you're in Texas, your notice requirement for summer is coming up. Remember, non-custodial parents, you have to give notice by April the 1st for your summer schedule. If no notice is given, then you have from July the 1st and July the 31st. Again, give notice of the specific time that you want the child during the summer. If you don't give any notice, then your summer visits will be from July the 1st through July 31st. Custodial parent, you have to give notice by April the 15th of the weekend that you would like to have the child. When the non-custodial parent has the child for 30 days and you want a child for a weekend, you need to give the notice of that weekend by April the 15th. In today's video, I will be discussing conservatorship and highlighting the difference between joint managing conservatorship and sole managing conservatorship. Conservatorship refers to how a shared custody of the children will be handled in the court. In Texas, both parents can be named joint managing conservators, or one parent can be named sole managing conservator. Texas courts believe that the joint managing conservator is what's in the best interest of that child. And so the courts will designate one parent as sole managing where there is evidence that one party demonstrates a high degree of negative behavior, for example, domestic violence. And so if you're going to court, if there are no domestic violence issue or issues that will cause the court to move from joint to sole managing conservatorship, believe that the court would appoint both parents as joint managing conservators of the children. That's what the courts believe is in the best interest of the children. Now, with joint managing conservatorship, each parent shares in the parenting duty. Parties also have same decision-making power. However, the court would usually pick one parent as the primary, and the primary parent receives child support unless the parties can show why an order for no child support is in the best interest of the children. And this parent also is the parent who has the right to determine the residence of the child while the other parent gets visitation. Sole managing conservatorship. One parent in this case has the right to decide the primary residence of the child. One parent consents to medical, dental, and surgical treatment involving invasive procedure. One parent consents to psychiatric and psychological treatments. That particular parent also receives child support, makes decisions regarding the child's education, represents the child in legal action, and makes a legally significant decision concerning the child. And that parent also consents to marriage and enlistment in the armed forces of the United States for that child. That parent also has access to earnings of the child, acts as the agent of the child in relation to the child's estate. That parent also applies for and renews the child's passport. There's a significant difference between sole managing conservatorship and joint managing conservatorship. With joint, again, you both make decisions except for a couple of decisions left for the primary parent. Now, there are several reasons why a judge might grant one parent as sole managing conservatorship. And so some of these reasons include this. Number one, the other parent has a history of family violence. So where there are issues of family violence, the court would appoint one party as sole managing conservator. Number two, neglect. The other party has a history of neglect, a history of drug and alcohol and criminal activity. In such situation, the court would move from joint into sole managing conservatorship. In cases where one party is absent from the child's life and that there are history of extreme conflict between the parties over maybe educational issues, medical issues, or religious values, the courts would typically find that a sole managing conservatorship is what's best for the child. Click below to access my life coach program for coaching on effectively handling your custody battle. Remember to follow my channel to learn more about the legal process. If you have not already done so, be sure to subscribe to my channel, turn on the bell notification so that you are notified when I post a new video.